who believes that Clemens is right in giving his definition of the common law? Because I'll open the floor for anybody who wants to discuss it who thinks that he was correct. Go ahead, buddy. Yeah, I think you might be better now, actually. There we go. Yeah.
I had to go in the
Yeah.
settings on
There you go.
the main part.
No
Amazing. Even
biggie.
though it says allow the microphone for Twitter always, it wasn't allowing it. I don't get it. Oh well.
Yeah, the settings will block your mic altogether. So you got to be able to get through that first, you know?
Okay, I'm
But
sick,
definitely
so
nice
we'll
to have
see
you
how I
on,
go.
sir.
So, um, my understanding, what I understood what Clemens was saying, whether that's common law or not. I, I, under, I understood what he was saying. What I
Uh
didn't
huh.
understand is what you are saying common law is. So you read a
Yeah.
definition. So just give me a sentence or two and tell me what you think common law is. And
Well, first of all, on what I requested, because if I tell you what common law is now, then you can say that's what common law is. I wanted you to tell, because you said you believe Clemens was right. What about what Clemens said about common law was correct? And then I'll give you a full definition and a short dissertation on common law, and then I'll prove it with writing so you can see.
okay, well, I think what Clemens was saying is the legislature writes statutes. There's a whole bunch of them. They're conflicting, and then there's a body
Uh,
of case law that they get interpretations, and you can agree or disagree whether they should be doing that. And eventually, they come to some understanding, and that becomes the common law. I think what
okay,
you're
give me
going to
one
tell
second.
me, and I've heard this
Give
be,
me 1 second.
am I
Give me 1 second about a word you said because I need to get understanding of what you mean. When you say case law, what do you mean?
well, all right, case law means, in my mind, when you go into a courtroom, they look at what
Hmm.
a previous case, how it was decided, and they try to be consistent. So you don't have one judge saying something completely inconsistent from another, and they try to build up a body of case law.
Okay, so would that be case law or would that be the word precedence?
All right, all right, I'll use precedents. That's fine by me.
No, no, I'm asking you because there's a difference. See, if you say case laws, see, the only way you can know the term case law is if someone told it to you or you read it somewhere. And what I'm asking is, are they mixing the words up? Because if you say the word case law and call that a body of law, that would imply that judges can make laws.
Okay, so I'll go with precedent. I won't go with case law,
Gotcha.
and technically you're correct on that. But
So case law would be completely wrong, right?
technically, judges cannot make law. So using the term case
Gotcha.
law is wrong. Yes.
Amen.
So
So we
they
are
use the word, but they do they use a different word for it. They call it precedent, as you're pointing out. But when you go into a court, they do it all the time. Should they
no,
do it?
they call
No,
it
of
case
course
law.
not.
They call it case law. You were 100% right. They call it case law, but here's the problem. We, the people, create constitutions and we are the grantors of authority. The only place you will find the law creation authority in any constitution, state or federal, would be the legislature. So the legislature makes law. The executive branch might make some rules about how they handle their business. The court might even have rules, but the only one who can write law is the legislature. So when judges try to make us believe they're creating a body of law called case law, is actually a lie because judges only make judgments based off of two things: the law that the people created in the Constitution and the law that was created in statutes that's in pursuance to what we created in the Constitution. So they're not making new judgments ever. They're only making judgments based off of what we granted them ability to have jurisdiction over.
Yeah. Well, if you try to go into court and argue that, good luck with that one,
Well,
because we both you
we've already
just
won
admitted.
thousands of situations, so I don't think
Well,
it's good
you
luck
can't
because
interrupt me. You got to give me a chance here, okay? And then you can talk. So when you go into a courtroom, should they do it? Should it be called case law? No, you just said it's called precedent. I conceded to that. That's true. It's
Mhm.
called precedent. But judges do it all the time. Go into court and try to win with the argument you just said, and it's going to be very difficult because that's the way they're taught and that's how it works. Should it
Okay,
work that way? Probably not, but it does.
okay, so you're telling me that I can't go into court, or I don't have a history of my people who I taught going into court and winning doing it this way?
You can. It's just difficult. I mean,
Wait, wait.
they use precedent all the time. I mean,
No,
that's
no,
why they
I'm not
cite the
speaking about the
cases.
president. I'm talking about your comment about winning the way that I'm saying the things really are in law. Are you
Well, you
saying,
can. I mean, let's take the 14th Amendment, right? It doesn't apply to anybody that's not under the jurisdiction of the Constitution. Yet we have people dropping babies in the United States, and bingo, bango, they're citizens. Now, if you look at
okay,
the Section
wait,
1
wait.
of the 14th Amendment, it doesn't say that.
Well, dear sir, we're getting off the point though, because you made a point. And see, this is why I have to kind of object a little bit. You made a point about try to go and win in court with what I'm saying. Now, I need to know if you have firsthand knowledge of victories that we have here by
No, no,
destroying.
I don't. I
Okay,
don't know who you
okay.
are. I'm
I
sorry. Are you a
thank you so
lawyer?
much.
I don't even know.
I appreciate that. Thank you so much. See, because I just wanted to make sure, because the audience don't know either one of us that well in many cases, and you don't know me and I don't know you. So I wanted to know if you were making a claim based on knowledge of what I do and what my people do, or if you were just saying it doesn't work that way. Because right now in America, we have the ATF falling to nothing after we put the Supreme Court on notice, and OSHA, and the EPA, all of these administrative agencies, we put them on notice ahead of time and told people what was going to happen based on the law. And the Supreme Court came out and confirmed everything we said. And now the ATF has no power to do what they've been doing. So when you say they do it like this in court and you won't have success, the Supreme Court itself is saying the whole administrative system and the Bar Association and bureaucrats have been using the law wrong in the recent Bruin case, and that over these decades, they've been doing it wrong, harming the people by things that are not law. So when you say you won't win, the Supreme Court is proving that the people are winning right now. So I'm just trying to understand, is it that the people will have a hard time doing it? Or could it be that it's already happening and you might not be in the know of what's really happening and what really works?
Well, I'm saying I shouldn't have said can't win. It's difficult because, I've been to court probably a couple hundred times.
Okay.
And I'm telling you, they always come up with the precedent thing. And as a scientist, I'm reading the letter of the law, or I'm actually looking at the legislature and looking at the congressional record and listening to the debates. And I don't know where these judges are getting their rulings from. They do it all the time. I
So
mean,
they
they
were
just
doing,
do it all the time. Now, should they do it? No. Can you occasionally get that reversed? Yeah, Roe v. Wade got reversed. Absolutely, you can get that reversed. It's tough, but you can do it. And if you're a lawyer that's doing that, I applaud that. That's
I'm not
fantastic.
I'm not a lawyer actually. The reason I'm doing it is because I'm not a lawyer. Because the
Yeah,
lawyer
that's what I say in court too.
Yeah, the lawyers always teach the wrong thing because they've been taught the wrong thing. And this is why this gentleman thought he knew what common law was. So let me,
Okay, so I'm guessing you're thinking common law comes. This is the definition I've heard. I don't know if this is the one you would use,
uh-huh.
but it existed before the Constitution because our rights come from God, something along those lines. Is that
Not,
correct?
that's not what I think common law is.
Okay,
Would you?
enlighten me then. I mean, I might be wrong. I don't know.
Yeah. So, but this is amazing though, because you are a smart man. I can tell you've been to court a lot of times. You seem to succeed either in business or your field of study. So that tells me that you've dealt with these people a lot of times. You're telling me you've seen the courts and what they do a lot of times. And this is an excellent education for the people. Because if you've seen what they do and you can say what you see and you have an idea of what you thought I would think common law is great, because it would mean that I might have a definition of common law that you didn't speak yet. And
Yeah, you might.
you didn't see.
Enlighten me. I mean, I'm here to learn. Go
Yeah.
ahead.
So common law is it actually is the law that deals with the rights of the people and how the government as servants protects those rights and their property. So what happens is the people have what's called common rights. Common rights are derivative of the common law. The common law are the rights that are common to all men. The state constitution is a trust indenture. Inside of the trust indenture, we grant authority to our servants, And what happens is we tell them that they must, in order to work for us, that they must protect certain rights, property, and then we give them a set of orders or a frame called the frame of government, where we tell them what their duties are inside of the republic. Republic being res publica, those things, matters, or affairs open to the public. So they have to protect our private rights, and then they have to go and carry out duties and functions by obligations over our rights. So common law is that relationship of how they protect our rights, and then how judges take the rights that we already gave them, the powers we already gave them, and the law we already gave them, and they are to affirm, confirm, and reaffirm the law based on what we granted and what we said. That's common law.
Yeah, so that's a different way of saying what I thought I said. So in the Declaration of Independence, which preceded the Constitution, it talked about unalienable rights. In other words, you're born and you have certain rights that are granted to you: life, liberty, the pursuit of happiness, and they are enshrined in the Constitution, right?
Well, not
So
not
that's
right.
essentially what you're saying.
No,
I
no. You said
think. Am I missing
granted
my
to
point?
you said granted to you. That's not it. We create the law for ourselves, and we delegate to them authority, and we tell them what our rights are in the state constitutions because we wrote it, not the government.
Right. Okay. I agree. So we agree on that.
So can I show you the book definition though, so you can see if I'm right?
Yeah, go ahead. Let's hear it.
Hey Denise, somebody, can y'all open up Black's Law uh, fifth edition and open up the word common law so we can look and see if it's what I said. Anybody here got Black's Law fifth edition up? If you got a mic, if you need a mic to pull it up, let me know. If
Hey,
you got it,
yeah, well, actually, I just was taking screenshots of fourth, but you want me to get fifth too?
yeah, open up fifth for me, and I want you to open up the word common law.
Okay,
So,
I'll take a
sir, I'm
picture
going
of the
to,
front too so he can see the book we're using.
yeah. So,
Okay.
sir, in Black's Law fifth,
Yeah,
which,
I know what Black's Law is. Go ahead.
oh, no, 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 no. I was going to tell you, I was going to continue to make my point from Black Law fifth. So, when Clemens said that uh, in American law, common law is based on the body of statutes. Well, a body of statutes cannot make common law because in American law, the government doesn't have power to write common law. So when you look at the beginning of Black's Law Fifth, it's going to tell you that it's distinguished from law created by legislators. Legislature has no power over our private rights because we dictated them in our form of government. Therefore, we're not like England, where a parliament can say something about our rights or make some edicts or some garbage like that. We dictate what our rights are. So, being that we dictate them in American law, the legislature can't write common law. When you have a statute can only be in pursuance to the frame of government that we created, the Constitution, right? So when they write something, they can write about their procedures to handle our rights, but they can never make a bill that would go against our rights. That goes against the trust indenture. So, Denise, can you read Black's Law Fifth Common Law for us, please?
I sure can. I was just about to drop the screenshots in. If you give me a second to do that,
Thank you.
that way it's in front of everybody else. And I tried reinstalling like Summer did, thinking it would allow me to co-host. It still didn't do it.
Wow.
So
Hmm.
I tried. Okay, so here's the first page because it's split between two pages.
And it's going to show three different definitions. So we have to apply what is what for American law. But go ahead, please.
Okay, well, there's the first one, and I'll start. Let me get the pictures in here just right quick, and then I'll read it all. How about that? Sorry, Dave. I thought you were going to go for fourth. That's why I went there first.
Mm-hmm.
Uh, I'm sorry, gentlemen and ladies. Give me 1 second here. Okay, so do you want me to include as distinguished from the
Yeah.
ecclesiastical law as well? Okay.
Well, no. Start where it starts. So
No?
it's going to talk about
Well, no. Okay.
because we
Yeah.
don't have that here. So
Okay.
it's
I
going to
know. That's why I thought that wasn't relevant.
yeah.
But
So
here,
as
yeah, here.
distinguished from.
As distinguished from law created by the enactment of legislatures.
Mm-hmm.
The common law comprises the body of those principles and rules of action
Uh-huh.
relating to the government and security of persons and property,
Okay, stop.
which,
So what
oh,
what I gave you earlier was it deals with the government, how we grant them power and them having to protect our rights and property. That's the first part, right? So that's the body of law and rules of action. Now, when you look at actions, you're going to have two important types of actions that I talked about with Clemens that he didn't understand. But one is a statutory action, the other is a common law action. Now, I'm going to prove it in a second, but go ahead, Denise.
okay, let's see, relating to the government and security of persons and property, sorry, I repeated that, which derive their authority solely from usages and customs of memorial antiquity.
So it didn't say it comes from anything with the legislature at all. It didn't say it comes from judges making up their own precedents based off of what they want to do in recent cases. It's immemorial antiquity, customs, usages. All that deals with the people, not government creating it. So when Clement says that the common law is a body of case law where judges are making law based on their new decisions, that's a hoax because there's no way that a judge can make law. That's why I just established the idea of case law with you, that it doesn't exist. So the Black's Law Dictionary says nothing about case law. Something called creates law that creates law. That doesn't exist. All right. So can you give me some more, Denise, please?
Yes, it continues on, or from the judgments and decrees of the courts recognizing,
Okay, stop.
affirming.
Now, this is
Okay.
important for everybody who's listening because when you say a judge can make a case law based off a new argument that some idiot makes who calls himself an attorney and smart, what you're doing is you're giving the court the ability to not use the historical custom and usages. You're allowing them to bring things into precedence that do not fit with the common law or that which is from immemorial antiquity. See, this stuff goes way back and they want to do a new thing. So when you say they shouldn't be able to do this, the reason they shouldn't be able to do this is because it goes against the common law and the very definition. Now, what Clement said sounds smart. It sounds like he had confidence. It sounds like he knew, but the definition says it comes from a body of case law where the judges make a judgment on the statute. Never said that. That's not consistent with the book. What else does it say, Denise?
Okay. After recognizing, the courts recognizing, affirming, and enforcing such usages and customs.
Wait. Read that again, Denise. You might have missed a word.
Affirming and enforcing such usages
No.
and
Go back. Go
customs.
back. Go back a couple of words, like the beginning of this
Oh,
last.
decrees of the court. I read that, but I'll
Yes,
read it
ma'am.
again.
Read it one more
Okay.
time. So we
Okay.
hear because I
So,
said affirming, confirming, and reaffirming what
right,
we
right.
already wrote in law. So let's hear.
Okay. Okay. After immemorial antiquity, it goes on to say, or from the judgments and decrees of the courts, recognizing, affirming, and enforcing such usages and customs.
Okay,
And
so they are enforcing usages and customs from history. Did it say that they're reinforcing statutes?
no,
Didn't say that, right? All right.
no, sir.
So when Clement said it's a body of statutes the judges are going to make decisions about it, and over time, whatever they make decisions about on the statute is going to become case law. You can't separate them, Dave. They're going to be connected. The fact that the legislature can't write a statute over our rights and we grant them authority and tell them what to do and we dictate to them what our rights are, it makes it impossible for them to write common law. Therefore, no judge can take their dumb statute and create a law out of it, something new, because they want to make a decision over our rights because we never granted that authority to government. The judges are only supposed to go back to the historical law that has already been established by the people, not the government in America, and make decisions based on that. So, dear Sir Buddy, so far as we're going, did it say what Clement said or did it say what I said?
Well, I didn't pick up on you saying that in the initial discussion. Okay, so I'll agree with you. Let me ask you a question.
Yes, sir.
If Clemens would have used the word precedent instead of case law, would you be okay with what he said?
No, sir, because I asked him purposely if there's a statute put into a case. I said, sir, when you put a statute into a case, the only thing you can get out is a statutory action. And then he tried to jump before me. He said, no, it's not administrative, Dave. The reason he said it's not administrative is because he watched videos where I told that these courts are acting in an administrative function because legislatures write statute to dictate to the government how they're going to handle our business. So when they're doing statutory hearings or administrative hearings, that's just government business. It has nothing to do with the rights of the people. So if you put in a statute to say statute 42.5 says that no person can go out during COVID. Statute 42.5 is only administrative because you can't interfere with the liberty of the people because the government was never granted that authority. So even if he said the word precedence, it would be wrong because there could be subject matter jurisdiction in a case over the people's rights because we have in personam jurisdiction over the government.
Okay,
Now,
so
the reason we don't,
you could take that to
okay,
court and win that case on that, then, right?
we've won in thousands of situations. I'm the guy who
Right.
protected all the
Yeah, I like that
PMAs.
argument. That's a decent argument. That's a very good argument.
Yeah, the
I think.
PMAs. I'll just tell
Yeah,
you real quick.
I understand what you're saying now, and I got it. I didn't pick up on it when I originally jumped in the conversation.
No, it's okay. It's okay. I appreciate you for talking though, because
But
you're
I understood what Clemens was saying. Here's a question I have on my mind, and I don't. Maybe
yes,
there's a
sir.
lawyer in here who might know the answer. If you were to walk into a law school and use the term case law,
Mm-hmm.
I mean, because a lot of terms are, they're not used. You can say them in engineering circles, and we use them improperly all the time. I
Mm-hmm.
mean, we shouldn't do it, but we do.
Okay.
And every engineer, every scientist would know what you're talking about. And if you actually looked in a book, yeah, we're not using it right. So I wonder if you went and said something to a lawyer in a law school and said case law instead of the word precedence,
No, no.
if they
I
would understand it that way.
I
I'm
think you
just curious.
misunderstood me, dear sir. I understand what you're trying to say, but I think you're missing the whole thing with that
Okay.
part. So the word precedent, sir, if you look at the Maxims of Law by Charles A. Weisman, he has a
Mm-hmm.
collection of 1,600 maxims that tells us from our forefathers of law, like Koch and Blackstone and those guys who are known as authorities in law, the most
Mm-hmm.
brilliant guys in law. When you look at what they say, they tell you that it's not possible or it's not lawful to bring things that are derogatory to the common law into precedence. So, in other words, you can't have precedence that interferes with the common law. So, when you got attorneys who were taught differently ever since the 1930s because of the New Deal, you can see in the book Administrative Law and Government by Kenneth Cope Davis in the first chapter, he tells how they started to retrain attorneys differently because they wanted to be able to deal with the complex new things, right? The complex new things that had to do with agencies and such. And they wanted to be able to grant agencies the power to hear the matters rather than actual judges. So when that happened, they started teaching the attorneys differently and they changed the definition of court of record, which is necessary to take anything from the people. They changed the definition on purpose between Black's Law fourth and fifth, and I can prove it to you now, in order to be able to hear cases where they could take stuff from people and nobody would understand that this is not law. So they would believe when they say the word precedence that you can bring something into precedence that's against the common law by removing the definition of common law out of the court of record definition in Black's Law Fifth. So in Black's Law Fourth, there's 5 attributes to a court of record. I'll blurt them off to you real quick. A court of record is a court that must keep an immemorial record. A court of record is a court that must have a tribunal that is independent from the magistrate. They can't be working together. The judge can't be working with the prosecutor, can't be working with the agency. That's automatically impossible in all the federal programs where they're all being paid under the same title in a federal profit making program. It also says that the court must move by common law. That's removed in Black's Law Fifth, and that's very convenient because if you're not using common law, you can now bring in things that you call precedents that has nothing to do with the common law, just statutory business. Now, also, it generally has a seal, and it has the right to fine and imprison for contempt. This is why in most agency hearings you have, they can't imprison you for lying. Is because it's no longer an actual court of record, is not moving by law. Now, I can prove it with the actual words of the book. And this is why it's not a situation of people mistaking the word precedence for case law. I was just showing you what you were saying. You didn't mean case law because case law doesn't exist in any law in America or in any law book. It
Hmm.
doesn't exist.
Well, I'll tell you, I've been to court a lot, and
Mm-hmm.
actually, I agree with what you're saying. I've had this argument with my lawyers before.
Mm-hmm.
So we lose, and I say the exact same thing you just said. And
Did you
he
say it or did you say it in the court? Is
yeah,
that what you
I
did?
say, wait a minute, this is a violation of it. I say it's a violation of the Constitution, which
Is
essentially my thinking is this: these judges use precedent all the time, and I read the cases and I go, yeah, but the case you're basing this on, that precedent is wrong. The Constitution says you can't do that. So my lawyer always looks at me and says the same thing. He goes, well, you got the money to appeal that up to the Supreme Court? And, usually the answer is no.
So let me ask you this way. So how does the law say you're supposed to present this to the court? Does it say you just say it, or how? Tell me in application how this is supposed to go into court, because from what I've seen in my experience, no attorney will ever tell you how to submit it to the court. As a matter of fact, if something was unlawful in the first place, your anus should never be in court because your attorney should have fought the jurisdiction before you went in there and not accepted the jurisdiction. The fact that you have an attorney and he's collecting billable hours automatically submits you to the court's jurisdiction. And I'll give
Yeah,
you proof of one. I'll give
yeah,
you a
I
proof
know.
of one.
I mean, even look at the Reigns Act. I mean, we've got the executive just, they say it's a regulation, but they're making law, and then the courts are ruling on it. It's
Yeah.
it's
Well, I'll
it's the
tell you
same
why.
thing. And when I go into court with lawyers, and you got to take a lawyer into court. I'm not a lawyer. I mean,
No,
I
you
guess
don't.
I
You
could go.
don't actually have to.
I
You
know
don't
you
actually
don't
have to.
have to. You can go pro se, but good luck with that.
No, you could go sui juris. Pro se means you're going to act as an attorney. That's professional self. You're not a professional law anything. You're just a man, and you have guaranteed rights. But I can show you a federal case that was a $2.5 million fine from the one of the wildlife agencies, and I can show you where Jaron Jackson, Clement's own friend, right? Clements is the guy in the video. Jaron Jackson is his friend. Jaron Jackson studied with me since March of this past year. Jaron Jackson put a 1.5 page document in the case that been going for 3 years, and he won the case with a page and a half outside the court without going in, showing his status, standing, and jurisdiction of the gentleman who was getting attacked by the government, and the case was killed. And Jaron will testify and tell you who was involved. It was a famous rock singer who came to Jaron to ask for help, and that case was won. It's a federal case, wide open.
Hmm. Well, good.
So this is the thing. When you attack one of these situations, right? You said you go in with an attorney. Let me ask you, what does the attorney tell you to do, or what would you do to get your rights on the record the right way?
Well, usually we have the discussion, and usually I'm taking your side, and he'll pull up all the what he calls case law. So
Uh-huh.
yeah, we're calling it precedents, and
No, no, no.
that's
Actually,
how
no,
the
no.
judges are taught, and
I
because
want you to
they
catch
were
this because
attorneys and they went through the law school, and that's the way they work. And I'll say, wait a minute, it's not constitutional, and if we lose, then he'll say, do you want to appeal? And it gets very expensive because
yes.
to get that heard and get in front of a judge that actually understands the Constitution, you have to at least go to appeals and then probably higher.
Okay.
And then you got judges that understand the Constitution because the low level judges don't.
Well, let me
They
tell you.
they
See,
do not.
this is what the law says. The fundamental law says it matters not what is known to a judge unless it is known to him judicially. So, in other words, if your attorney doesn't make the argument in writing, sworn under penalty of perjury to the judge, he can ignore it, and you don't have to pay any money.
Say that one again.
So, if you don't put it in writing, so the maxims of law say nothing is to be believed in court unless it is sworn, right? So when I have a fight with some of these guys online, they say something about me. I say, just swear to it on a piece of paper. I dare you. They won't do it because they know what the freak is going to happen. So in court, unless you swear in writing, sworn under the penalty of perjury in an affidavit, what your rights are and how the law works, the judge has never gotten judicially noticed, and he can ignore everything you say in court like it never happened.
Huh.
And I can show you this in writing. Now, I'm telling you this because I realize you're a brilliant man and you're a powerful man, but I realize that the attorneys aren't telling you the whole truth and they're not making it clear. And I think if you have it clear, if anybody tries to sue you, they're going to have a force to be reckoned with because I think you understand the real law enough to destroy a lot of people if they try to attack, which is your right because your property, your money, your business, your stuff belongs to you, and if government actors are using something that's not law to attack you, and you know how the process to destroy it, then it becomes way easier.
Hmm.
But the attorney don't make as much money. And I'll give you a real life example, and you can call and check on me on this. There's a guy named Mario who own a co-owner with two other gentlemen of a company called Mountainside Fitness in Arizona. They got like 18 or 19 gyms. They were getting beat down by the government because Ducey wanted to, Governor Doug Ducey, I'm sorry, lock down the whole freaking state. He was locking down people's gyms, restaurants, and he wouldn't let people get free. Well, I saw that he was breaking the law with one of my friends who had a gym. So I opened up his gym as a private association, put the government on notice, and totally knocked out. Riley, I'll have you read the maxim you got in a second if you wish to. Um, he knocked down the jurisdiction of the government. All the police that were coming trying to tell him to shut down stopped. They realized we can't do this no more, right? So I can show you where Mountainside Fitness, I created 18 entities, I believe it was, for them over a weekend where they couldn't open. They were paying tons of money to attorneys, and they even told me, dude, we're losing so much money. We were thinking about just shutting down the business altogether. Multi-million-dollar establishment across Arizona. I went in a meeting with the gentleman named Mario at Josh Barnett, who was running for Congress's office on one day, gave him information of how it works. He was blown away. He went and told the main boss. The main boss asked if I could come in. I think it was on a Thursday or Friday, and I showed him in the law how the attorneys were lying to him. I gave him a business card that I carry around that shows my PMA and the very law that breaks down the power of the government to interfere. Right? It's in their own law. And so I pulled out the card and I let him read it. I said, look, they always give you tickets with Arizona ARS 26-317, and they show you the first half to give you a ticket. I said, do they ever show you the second half? He said, well, no. I said, okay. So I said, so thousands and thousands of entities have been shut down, got tickets, people went to jail over 26317, and no attorney ever showed y'all the second half of the law they're using to prosecute you? And he said, no. I said, okay. So I had him read it. It says pretty much in the first half, any person who doesn't follow any lawful order during an emergency will be fined with like a class 6 misdemeanor, right? That it, get whatever you get for a class 6 misdemeanor. And then the second half after the period said that this does not apply to any private organization or member thereof to participate in an emergency. In other words, you have voluntary free will to participate in the emergency, and only the government is bound, right? So I showed him that. He turned blood red. He paid me like $9,000 and joined memberships with me. I went and opened up all his entities as private entities. He was open by Tuesday, never to get shut down again. No more news media, because the news media attack you when the government is getting you. They work together. No more news media attacks, no nothing. They put signs on the door. It was game over. No more fight. You could check me up on that. You could also check all the self-made entities from California. You could check Attila's gym the guy got arrested. Then he came to me. I gave him a PMA. As soon as he gave the government notice outside of court, he let the judge know he's going to go kick his doors down with Tucker Carlson videotaping from national television, and they wouldn't touch him again. No more arrest. He stayed open then. So I did this with hundreds of entities. I went against DAs directly in California, Arizona, New Jersey, and even on Indian tribal land. And I'm known now as the number one PMA creator in America. There's no attorney who can fight me or touch me. And I actually offer for them to come live with me any day of the week. As a matter of fact, you look at the Arizona audit, Perkins Coie wanted to shut it down. I was the guy teaching Karen Fan how to beat Perkins Coie and got the people involved. We put them on notice. When the DOJ tried to come, we put them on notice. They stopped. When the judge who used to work for Perkins Coie tried to stop the audit, we put him on notice with thousands of people. And he came out the next day talking about the people have a common law right to send their legislature to do their bidding, and they can send subpoenas even when they're not in session, and nobody can do anything about it, not even the court. Why did he say that? I wrote it to his anus the day before.
Hmm.
Yeah, so you're a brilliant man because you see that there's wrongs. The problem is that when you're a brilliant man and you're wealthy and people know that they could get billable hours, they're not necessarily going to tell you that the maxims tell you how to win. And I can show you where Thomas Jefferson in his time said that the maxims of law, he has never seen anybody judicially be able to beat the maxims. But then our schooling never told us about the maxims. Another one you're going to find that'll make you win a lot of cases. How come no attorney ever tells you about the state constitution and how the government is bound by it, where they can't attack your entities, your life, your business, you, based on the contract they have in the state constitution? No school teaches the state constitution. No law school. Nobody. As a matter of fact, Jason Fick's attorney who fought Facebook, he met me, and I started showing him what was in the state constitution. And I started showing him how I did work to make the Supreme Court go after the ATF, OSHA, and all this. And he's like, man, me and the other attorneys in DC were looking like, why is the Supreme Court flipping and dogging us? They're not giving any victories to the attorneys when it comes to the people's business anymore. We had no idea why it happened. But then he came out and said on the call in front of Josh Barnett and Jason Fick, but now I realize it was you guys. David, you think you're slick. You've been hiding, tearing up DC, and nobody know how you did it. But I sit up here reading your notices. I know exactly what you did to the court. I see it as plain as day. I've never thought to do it this way, but it's you. And I'm telling. I'm like, dude, you don't need to tell. Like, I want to walk around still, right? But it's proven. Like Jaron Jackson, who's down below Denise to the left, he did a video not too long ago, right? Now, a lot of people will say what works in the law, but they won't show you proof, right? And then people started saying, well, you know what? Uh, there's no way you could be doing this, David. You're just full of crap. I said, well, what about this? What about I'll stop telling you what I'm doing with the government after the fact? I'll just tell you what I'm going to do before I do it. Write a notice, go live on video, tell everybody what the notice is going to do, how Jim Jordan, because we're only going to send stuff to Jim Jordan, he's going to tell on everybody based on everything we say. And then I'm going to make the Supreme Court tell on the administrative courts. I'm going to make them tell on the ATF. I'm going to make them tell on OSHA. And all y'all can see it. If I'm lying, you got my words right here. So I don't want to hear nobody else say we didn't do this on purpose or it was just a happenstance 100 times, right? So Jaron made the video. Now, Jaron wasn't even my friend a year and a half ago. Jaron was really close friends with Clemens, the guy I had the battle with. But Jaron, and he's here, Jaron can tell you if I'm lying. Jaron just won the case that the guy had 2.5 million in fines with a 1.5 page document outside of court, ex parte.
Hmm.
Literally ex parte. Like, did you know we have the right to order the government in what to do ex parte, and that the adversarial parties that come against us don't have the power to interfere?
No.
Okay, this is crazy. What state are you in, if I may ask? I'm not trying to get in your business, but
Oh, I live in San Diego. I tell everybody that.
San
California.
Diego. Okay.
I just lost a case. I can't believe this. The board of directors hired a lawyer. The lawyer entered into a settlement agreement with the other lawyer, but we
What?
never signed. We never signed off on it. And I said, "What?" I said, "Go back. We don't want this agreement. You know,
Uh
he
huh.
told you to do this."
Yep.
And they went back into court, and the judge upheld it. Said, "No, you hired the lawyer. He represents you. He signed for you." I said,
Ooh.
"What?" And so now I'm faced with, do I go to an appeal or not?
You don't have to go to an appeal. Did you know in California you have the right to instruct the government and tell them what to do,
No.
even on the
What?
state
I got to
level?
get a pencil. This is getting good.
Yeah, I mean the thing is, I could tell you were a powerful man, And so the thing is, see, if we take the powerful people in America, right, and we leave you hanging and bad stuff happens to you, if you have business and you got a lot of people who work with you or for you, what ends up happening is that you're the first line of defense. If they can destroy you, then the regular little guys like us, we don't have as much hope because you bring the jobs for us.
Hmm.
So if they want to tear down the economy, the first thing they got to do is attack you, because if the money can't be produced that you produce, then we can't have a strong economy. So I'm going to show you something that's going to be funny as heck. So I want you to look at your constitution. I'll send it to you. I'll send you a link, and I want you to read this out loud because you're going to die.
Is it Article 1, Section 1?
No, sir. It's Article 1, Section 3. It's good to look at Ballotpedia. Article 1, text of Section 3.
Okay, no, Denise sent me Article 1, Section 1.
You got to look at Section 3. It's going to blow you away.
Well, I'm a little leery about leaving here, but let's see what happens.
No, no, I'll
Oh,
send it to you
hey,
picture.
Denise, just send it to me on my Twitter.
Okay, tell me what you see.
Yeah, she didn't do it. Okay, hold on.
Now, notice they never teach you the state constitution because the federal constitution is not the trust indenture for the state. Most of the duties in the federal constitution is for the federal workers. There's very little for the state workers, right? They got to honor it, but it doesn't tell you what their job is or what they must do.
Oh,
Now,
yeah, I got it here. The people have the right to instruct their representatives, petition government for redress of grievances, and assemble freely to consult for the common good.
okay, so attorneys consult, right? So the people can consult for our own lawful common good, like we're doing right now. We're talking about the law, but the attorneys say you can't talk about the law unless you're an attorney. What? The whole government swore in the state constitution we have that power. What are you talking about? But since they don't show it to us, we don't know, so we won't make the argument, right? So to take it further, you got the right to do what to your rep?
Uh, Petition the government for redress to instruct your representatives.
Woo! Instruct. What? Wait, hold on now. So the attorney didn't tell you you're supposed to instruct your representatives to blow the back out of this dumb judge and this dumb attorney who thinks they could take your rights and just sign them off without consent?
So, representatives, you're talking about the Assembly and the Senate in California?
Yes, you can actually order. So in Arizona, we got the only full forensic audit in American history. I ordered Karen Fan in front of Katie Hobbs, the governor, and everybody else who didn't want to do it to go do an audit of all 2 million ballots, I told them to pick somebody they didn't even like, and they had to do it, and they did it, and everybody saw it. It got me kicked off of Twitter because Katie Hobbs was mad. She told Twitter, get rid of his get rid of his Twitter because he's telling everybody how to get the audits and beat us. So imagine you now, if the legislature is writing a statute that's infringing upon your right, and the judges are using some statute that's wrong, but you never get a chance to teach the legislature and instruct them on why it's wrong, then the attorneys could just keep doing wrong, right?
Okay, so you write this instruction to the state legislature. If they say, who's this guy? The hell with him, and blow you off. What do you do next?
That's not how it works. So here's what you do. The Supreme Court will give you, see, you just made one of the most brilliant statements ever. I almost started laughing, but I held my composure. You said, man, the attorney says to me, you want to appeal? How much money you got? See, he wants your money. So he wants you to appeal because he wants you to believe your only remedy and redress of grievance is to appeal. They're giving you one dumb option, and the attorney and the judge are all in cahoots. They're all bar members. They're controlling the system. So they need you to stay in their system long enough to milk your money, and they know that no high level Supreme Court justice is going to see it because you don't know. You could talk to them too. So when it says that you could petition government or give them remonstrance or redress or address for redress, you can take the Supreme Court case and bring it to your face today. What you do is you take an affidavit, you write it to the legislature. You CC the federal legislature, Jim Jordan or Thomas Massey, or both. You CC the Supreme Court about what's happening in the issue right now when you're not even in court. And you say, hey, look, the Constitution says this in the recent cases like Bruin and the such. You said the government can't do this, but right now, this little judge right here, he's purposely doing this to me and trying to ignore the law. So I'm letting you know right now, without even having to go to you, that this is what this guy is doing. This is what the attorneys are teaching, and they're playing together. And so, therefore, I'm going to tell this lower body, if you agree to pay me $20 million, I agree for you to attack my rights as long as you're going to pay me the $20. I want the Supreme Court to see what's happening, right? And the federal legislature. Now, what's going to happen is the acts that are done in the private in tribunals that are not judicial, where they attack you, the Supreme Court is going to be on notice that this is happening on the low level right now. And you're telling them ahead of time what's going on so the people can't deny. So now the only way they can refute you is to swear by affidavit that you're lying. Now, if a government official swears by affidavit, there's no more immunity because you can only swear as a man telling the truth. So now there's no immunity for them. So now they have to say, this dude then fool around and told everybody what we're doing. If we lie on affidavit, we're going to prison or we might lose everything. If we don't say anything, we're going to lose, but hopefully he won't figure out the rest.
Hmm.
So what ends up happening is they don't just ignore you anymore. They start trying to figure out how to fix it because there's no argument to have. See, the only way they can win is if they can argue over a statute or something. Once you take them to the highest rights, is no more argument. This is why the ATF is getting destroyed over and over and over again with tons of wins for us. They're getting destroyed because I went to the Supreme Court and said, hey, Supreme Court, you know darn well. And no, this is what I said. I said, we the people have come together and spent time educating ourselves on the fundamental historical usages of the law. And we realize that in all state constitutions, you agree that we have the power to have weapons. And even in your own Arms Act, it says that you can't interfere with private ownership of guns. So therefore, we wish for you, Supreme Court and federal legislature, as trustees to immediately come out and tell these clowns that they can no longer do this to us. And they told, I gave Gorsuch and the Supreme Court 14 days to tell. On the 13th day, Gorsuch came out in a case that didn't even have anything to do with it. And he said, we usually like to say that we're working in judicial courts. This was on November 7th, 2022. I can show you the quote. We usually say that we're working in judicial courts, but uh this ain't the truth. He said we've been tipping our finger on the scale of justice, and not just for any litigant, but for the federal government. So, in other words, we've been cheating for the federal agencies. And then he said, we say that you have to have an impartial judge, etc., but that wasn't happening. So he just told on everybody. So we're all cracking up because we know what we told him to do 14 days before, right? Then we did it a couple not too long ago. We did it again, right? And Gorsuch came out and Kavanaugh came out and said, I talked about legislative tribunals, which is not a term you hear in any court. No attorney talks about legislative tribunals. You don't hear that. I put in a document, hey y'all, let these people know that they've been using attorneys and bureaucrats and legislative tribunals to take away people's rights outside of the constitutional mandate, is the word I use. You don't hear attorneys saying that. Well, then Gorsuch and Kavanaugh come out and say, look, you can't just change or relabel causes of action to bypass to bypass constitutional mandates um, in legislative tribunals. I can show you the notice. I can show you the video Jaron made where I say ahead of time in all these situations, watch, give me 2 weeks, give me a month, watch what happens with the Supreme Court. Guaranteed they're going to break. Guaranteed.
What was that acronym PMA? What's that stand for again?
It's a private membership association. So when they try to lock you down, right? A private membership association is the most hidden legal entity in the nation. And I mean, it's one of the most powerful. Like for instance, when there was a loss, right? When there was a loss, well, it wasn't really a loss in Alabama, where it was a racist state way back in the day, 1958. The Alabama government didn't want the NAACP, colored people, right?
Mm-hmm.
They didn't want them using their practices and business in their state. Period. They were a PMA. They ended up getting sued by Alabama to take their records and delve into their business and all that. And they ended up going to the Supreme Court. The Supreme Court, all white, voted 9-0 that the NAACP had the power to ignore the state and their power of inquisition because their entity was private. They had the right to handle their lawful private interests privately, meaning outside of government. Remember, governments are republics in America. They only have power over the public things. As soon as you're acting in a private capacity, they lose jurisdiction. And they didn't know that completely until we start tearing this up. But they lost in the 1950s over this, and then they just don't tell people. So then, if you don't know what the law says, they could just beat you up, and the attorneys love taking your money because they know um, if you don't bring up the argument, nothing is going to happen, right? So they're not going to bring it up for you. They're not going to tell you. The judge knows if you don't bring it up in writing, it ain't never happened. And then in the statutory courts, they put in there that they can strike every bit of evidence you give, period, if it's not fundamental law.
Well, David, I'd have to say you spun my head around here. Thanks a lot. My wife's giving me this look, so we got to take off. We have an appointment.
Hey,
Thanks
well,
for.
it's definitely
I'm
good
glad I
talking to
did
you,
this.
sir.
This was really cool.
It was definitely good talking to you. I appreciate you coming on and just having the discussion. Like we all need to learn and grow and help each other. And I've always been one to help the businesses. I've always been one to help the people. If it's elections, if it's vaccines or something that's an open issue that's hurting the nation, I've always opened the door to publicly destroy the government when they're doing corrupt things. So thank you so much for coming, though. It was fun.
Thanks, David. Bye.
Have a blessed one, sir. All right. So I guess we can open up.